Okay, okay. Oh, so if you want to talk, I've got the control. Okay. Okay.
Yes. Speak now. Zoom on is all right. Yes. Yeah.
Just have to go for that.
Make a start.
I think we're going to start. Yeah. So are we? We are. We streaming this thing.
Yeah.
Right.
Okay. Good morning, everybody. Welcome to the meeting. I'm in Westport with Simon and Mayor Russell. I wonder if we could just check the input from others. I'll ask to go around the screens. It's important that we all participate fully in the meeting. So, Paul, you can hear us loud and clear? Good. Lois, is that okay? Thank you. Councillor Webb, is it? Linda, thank you. Just got something on the screen there. Joe, I guess you're good. Francois, you're good. West Coast Regional Council. Right, thank you. And I'll just have to move something out of the way of the screen because I can't see the other participants.
It's what that messaging one.
Yeah, it's restarting 5 minutes.
Restarted.
No. It says restarting 5 minutes. Because it's configured from that email.
Sorry about this. We'll just have to wait until we tidy up the screen.
I'll see. Okay, restarting 5 minutes. So I can restart now.
But just done that like there's a
mandate.
Start retrying. Was it? But yeah.
Okay, I'll do that.
Until it was.
Yeah, okay. I'll wait. Yeah, so it's a mandatory restart, like can't be changed from the admin side also like this. It rolls out and it wasn't done earlier by other person. So I think might be 5 minutes.
We can't. We're going to stop the meeting. So if you click restart in 5, you can't pause that.
Okay. Well, I think we can hear everybody. We're just having a few problems here. Just confirm, Gray, just for council.
Managed from that.
You're available there?
We're going to have to restart it. I'm sorry.
That's okay. Just going to restart the session.
Yeah, so we'll have to restart, sorry, and then reconvene the meeting so people can just wait online and we will restart. We'll have to do that now.
Yeah.
Sorry.
That's okay. Can you just make sure everyone understands that? I certainly don't, Simon.
So sorry, everybody online. We're having a compulsory restart on the computer for a security update that it's not letting us cancel. So I'm really sorry. We're going to have to pause while that happens here. If you just bear with us, it should take hopefully 5 minutes. And so we'll be back online in 5 minutes. So so the link will stay the same?
Yeah, it will be the same. We'll just join the same meeting ID.
So it'll be the same meeting ID, same link.
We'll just join
we're the host. So will it cancel? What will happen to the meeting? Will it just end if we're the host?
I think he's hosting from here, yeah, so it's.
So,
going to
okay, so it'll just be us.
Just be us.
Okay,
Yeah.
so the chambers will go offline for a few minutes and we'll rejoin the meeting, sorry.
I think we can stay on, he said.
Yeah, sounded like it.
Yeah.
Yes, I think so.
They'd be very good at NASA. Space.
Great.
Okay,
Yeah.
do you think we're away again?
Hello, can you hear us?
Yes, thank you.
Thank you.
Yeah.
So we'll start again at 9:10, and we've got everybody on the screen now, and I welcome Alice Barham as well, and she'll contribute later in the meeting. So in Greymouth, we've got the full muster. Thank you. Right, so welcome to the meeting. Do we have any apologies for the meeting, Joe? No apologies, thank you. Any particular conflict of interest declaration? Nothing more. Is there Joe, can I ask you, is there a register of interests from all committee members?
We don't have a register of interests, actually. I can send something around to everyone.
I think it would be appropriate if the committee agrees that with a fresh committee, particularly with the sensitive matters that we've got in the next few months, that a register of interest is prepared and is available. So if you could ask for that. Thank you, Joe.
Certainly.
The minutes of the meeting held on the 12th of December in Hokitika. Any comment as to the accuracy, completeness of those minutes? Seems to be none. I'll move that I sign those as a true record of the meeting. Somebody second that. Paul Metric, you're first in line. Thank you. All in favour? Aye. Carried. Thank you. Any matters arising from those minutes not otherwise covered in the papers? I don't see any. Simon, if you can also keep an eye out for hands raised, because I'm not very. Yeah, thank you. Right, so moving to the first paper, the analysis of the appeals received. I think over to you, Lois. Thank you.
Thank you, Mr. Chair. So largely just I'll just briefly cover what we've received. So we received 36 appeals on the plan. A lot of the appeals, I've grouped them in the report for you, I guess, in terms of the size of the appeals. So we have actually quite a number of appeals which are quite small matters, obviously important to the appellants, but some that are quite targeted in terms of the effect on the plan. So that particularly relates to zoning of individual properties or particular features such as significant natural areas or sites of significance to Māori on an individual property. So we have a range of those appeals. Then we have a group of appeals which are still reasonably narrow in relation to particular parts of the plan, but there might be, for example, the Department of Conservation have a big focus, obviously, on some of the ecosystems and biodiversity rules and also natural hazard mitigation structures. And so those appeals, I guess, also thinking forward, are probably things that we're able to progress, settling, hopefully, in a reasonably short to medium term time frame. And then we have some very wide ranging appeals, and these ones are a bit more difficult for us because they are a number of parties who've appealed quite large parts of the plan, and so those are the ones that we're probably going to take a bit of time working through. Just in terms of what that means for us, because we have these very large appeals which are appealed quite large parts of the plan, it means that most of the plan is under appeal. So only some quite small parts at the moment are what's known as operative, so fully effective. And so that includes things like the designations, which haven't been appealed, the hazardous substances and contaminated land chapters, very small chapters, they haven't been appealed either. But also, usefully, most of the zoning mapping hasn't been appealed, so that those matters are now fully operative. What we have done, I did say in the report that we had the appealed annotated version of the plan live. I expected that when I wrote this report. That's not the case. I expect it now to go live this week, and that's because we've recently received notice that one quite significant appeal point is going to be withdrawn, and that was in relation to the word site, which is used 297 times in the plan. So we've been advised by the Buller Conservation Group who appealed that use of the word site that they're going to withdraw the appeal. We're just waiting for the Environment Court judge sign off on that, and then the effect of that is it will actually make quite a large part of the plan fully operative, because that was the only appeal on quite a range of matters. So that's quite good news. It was an easy matter that looks like to settle, and so we have a couple of others like that where appellants have said they've appealed a word or and I think they've been thinking about it in relation to quite specific usage, but the effect of it is it's appealed its use right through the plan. So we have a couple of others of those that we're hoping to sort out quite quickly, which will then move the plan to being probably more than half operative. And I guess it's the big appeals are matters that we expected. The district-wide matters, provisions around ecosystems and biodiversity, and sites and areas of significance to Māori, natural hazards, they're all got quite large appeals. And then we've also got a lot of appeals on the minerals provisions. Quite a number of parties have appealed those. So those are the really major matters of contention. So I hope to, as I say, I hope to get the annotated appeals version of the plan up as soon as we've got confirmation of this withdrawal of the appeal around the word site. And then it will be easily able for people to see which objectives, policy and rules have been appealed and which matters are fully operative. Just, I have tried to explain in the report what the different types of terminology mean. So this is sorry.
Could I just ask you to pause?
Absolutely.
There, just because you covered a number of topics in that introduction. Any questions or comments from committee members? Sorry, Chris. No, you're okay. On Lois's comments today. Lois, if you could just again, perhaps slowly go through that, the withdrawal of the document. I understand the paper copies which are at the council offices will also be withdrawn. Is that correct?
Yes, so what we did in putting out the decision plan is we wanted to make it as accessible as possible for people who might want to appeal. So we did put hard copies across all of the councils and their service centres and libraries so that people could access that. But it isn't feasible for us to keep maintaining the hard copies because as things are, appeals are settled, it means that wording in the plan keeps changing. And so we're moving to, it will be just the fully online plan as the sole source of truth. It is possible on the online tool to be able to look at previous versions of the plan. So we've got a little explainer on the tool how to access previous versions of the plan so that people are able to see what's changed. And then as we settle appeals, we'll also update the information feed on the online plan saying this appeal has been settled in relation to these matters. So people will be able to sort of track progress of the plan moving towards being fully operative.
Yeah. Thanks. So a question from Paul Medwick, please.
Thanks. Through the chair, just checking regarding STASM, is it only the sites and areas of significance that are under appeal that are on pause, and the rest of the SASMs are applicable?
So in terms of the effect of the plan at the moment, all of these provisions have legal status. So we continue with the situation where the district councils, resource consent planners have to look at both plans when they're assessing a resource consent. So sites of significance to Māori are in effect, but they're not fully operative. So, and I guess that probably just touching on that, what we have got is I mentioned these very large appeals. We have two very large appeals, one from Groundswell and one from Nico Deer Farm Limited, which appeal all matters of the plan that arise from Section 6 of the RMA. So that's one of the reasons why we have they're very large appeals. That's about half the plan. And of course, we have these matters in the plan because we're required by law. So I don't know, perhaps later Ms. Barr might have a comment about how we might go about addressing those appeals. But they're the big ones that are probably holding up quite a lot of the plan going operative.
Okay, thank you.
Thanks. If there are no other questions, if you could carry on. Thank you, Lois.
I don't know that I had too much more to say. I guess, because it is, as you've probably gathered from my presentation, it's kind of things are moving every day in relation to the plan now that it's under appeal, because we are in this process of trying to clarify the appeals and trying to sort of clear away any matters that might have been, the appellant might not have intended to appeal them. And so that does mean that we'll be keeping very close contact with your planning staff just to keep them updated, because obviously it has real world effects for them in terms of resource consent applications and how they assess them. So just to assure you that we're doing that, and we'll keep updating our website and the plan website just to keep the public and users of the plan informed on the status of settling appeals.
Thank you. There are no other questions. Could somebody move that the committee receive the report? Moved by, is that Councillor Webb? Thank you. Seconded by Mayor Russell. Thank you. All in favour? Aye. Carried. Thank you. Moving then to the legal update on the mediation position. Oh, sorry, is that all that we the next move? Sorry, Joe, you.
Isn't it Lois's verbal update?
Oh, sorry. Yes, moving to the verbal update. Yeah.
Thank you, Mr. Chair. I guess just following on from my paper, we've now had what's called the Section 274 process complete. So that's when people are able to join appeals. And as we might expect, we've had a lot of additional parties come on board. Most of the notices that we've received, I think we've received about 206 notices of people joining appeals, but they're mostly people joining each other's appeals. So, for example, Forest and Bird have joined a lot of other appeals, either in support or opposition, and the same is the case for all the other appellants. But we have gained 11 new parties to join in the appeals. So we've had several new minerals companies come on board, and they've mainly joined the existing minerals appeals, but also joined the Dock and Forest and Bird appeals. So that's the New Zealand Minerals Council, Hardy Pacific New Zealand, BRM Developments, and Birchfield's Ross Mining have joined the appeals. Bullet Electricity has joined the West Power appeal. The Māori trustee, Te Tumu Paeroa, has joined the Pōtini Ngāi Tahu appeal. The New Zealand Agricultural Aviation Association has joined the Buller Conservation Group appeal. Should just mention that these are mostly in relation to specific matters. So often the parties haven't joined the whole appeal, they've joined a particular matter that they're interested in. The John Cagle has joined the Bathurst appeal. Karen Lippiat has joined the Forest and Bird appeal, and Ian Ball and April McKenzie have joined the Boyd and Others appeal. So that means that all up, I think we'll have 47 parties that have either appealed or joined an appeal that we'll be working with to bring their plan to operative status. Possibly, I should just mention, because it does relate to further papers in this agenda, that the three councils, Grey, Buller and Westland and Pōtini Ngāi Tahu, have also joined a number of appeals. And so we left now with the West Coast Regional Council is the only party who hasn't appealed anything, which is probably not surprising, but just an interesting thing for the committee to note.
Any update, any questions, sorry, on the verbal update?
Mr. Chairman, yeah, I just want to comment that, look, personally, I'm not surprised at the fact that we've got 47 parties, either as appellants or 274. I think we're all sort of mostly expecting that. I would hope that in many of the appeal points that we can work through proactively and dispose of them, you know, in discussions or at formal mediation without having to go to court. However, I think it would be false to think that we can do that with everything. We will be in court. It is very difficult to try and estimate what budget allocation the regional council needs to provide for around all of this matter and how much it's going to cost, because how long is a piece of string? But I think it's going to have a reasonable number in front of it in terms of where this is going to wash up to in terms of the budget, the actual cost that we're going to have to foot here. I don't think this is going to be a cheap exercise now. Thank you.
Thank you, Darryl. So if there are no further questions on the update on where the appeals sit at the moment, we'll move to the next stage, which is the process for the mediation, and go on from there. So, Joe, if you could briefly introduce and then ask Alice to present her paper. Thank you.
Thank you, Mr. Chair. Yes, we have Alice Baum, who's a partner in our firm, Wynne Williams, a legal firm that has been working with us for about the last 4 or 5 years now through the processes we've been undertaking in development and the hearing stages. So she'll be representing us at mediation and any court processes. And Alice is just going to tell you a little bit now about what that process entails. Thanks, Alice.
Thanks, Joe. Sorry, someone was just busting through the door behind me. Good morning, everybody, and hello to those of you I haven't met yet. It's a new committee since I was last here, having been away for a little while having a baby. So I am just going to very briefly talk about the mediation process this morning, so that you're aware what we're sort of embarking on now. As Lois said, we've got 36 appeals, and the first step in any Environment Court process now is a direction from the court that appeals go to mediation. So mediation, it's a form of alternative dispute resolution. It's an attempt to try and resolve matters without the need to fully prepare for and attend an Environment Court hearing. And to the point just made, it's certainly a lot cheaper to resolve things through mediation than it will be to try and resolve everything through Environment Court hearings. So mediations, they are set down by the Environment Court, and we work really closely with the Environment Court on a schedule that works for us and for all of the parties. They are presided over by an Environment Court Commissioner. So the court will appoint a commissioner to attend all of the mediations, and it's likely that we'll have one or perhaps two commissioners that are appointed to oversee the full suite of mediation so that we've got some consistency there. The job of the mediator is to help the parties on the day to facilitate discussion and to try and, I guess, bring the collective minds together to reach a resolution. All parties involved in each appeal are invited to the mediation. And perhaps a slight nuance here is that we won't be mediating necessarily each individual appeal. The appeals have been grouped into topics, and it will be the topics that are mediated. And we find that's the most efficient way because you've got everybody in the room that wants to talk about a particular part of the plan or topic in the plan. And it means that you don't then have separate mediations where you're talking about the same thing as at different times. So everybody's invited. Typically, the parties will bring their lawyers if they have them, and any experts that they might want to rely on in terms of trying to advocate for their position. And the way that they run is everybody gets in the room, everyone goes around the table and explains what their position is that they're there to represent that day. And then conversation typically flows from there, and you just spend the day or a couple of days trying to reach resolution. They definitely involve compromise on the part of all parties, and we'll talk, I think it's the next paper, we'll talk about how the committee sets its position for the mediations to direct us on what you want to achieve. Perhaps the other point to note is that the Environment Court at the end of the day is still the decision maker. So we'll work really hard in these mediations. We'll attempt to reach agreement. If we do reach agreement, we'll record that in a mediation agreement, and then we'll work with the parties to prepare the documents that have to be prepared and filed with the Environment Court. And if the Environment Court is happy, which typically they are, as long as what you've agreed is consistent with the law, then the Environment Court will sign it off, and at that point the appeals or the points in the appeals are resolved. And the plan can be updated. This perhaps another point that might be relevant, the cost of mediations. So the cost of the Environment Court Commissioners and the venues and all of those things is a cost borne by the Environment Court, not by the committee. And then perhaps just to touch on what our role is in the mediation. So obviously the committee's role is to set the position that it wants to set in response to the appeals received. And then our role as the legal counsel is to best represent the committee's position in the mediation to try and reach an agreement that's consistent with what you've told us you want to achieve. And if we can't do that on the day, then we'll have to come back to you. Or it will go on to an Environment Court hearing if there's just no way that the parties can reach agreement. And then the role of staff. So in each mediation, there will be a lead planner. That planner is the technical person that we rely on to give us advice around the the technical planning provisions in the plan, and potentially any other experts that will think really carefully about whether we need to take them along to the individual topic mediations. And then finally, we'll have a delegate who is the person responsible for signing off the mediation agreement at the end of the day and ensuring that it's consistent with what the committee has told us it wants to achieve in terms of an outcome. I think that's all I really had to say about the process, unless there's any questions.
Thank you, Alice. Questions? I had a couple of basic questions, if I could, Alice.
Yeah.
Could you confirm that these are not public sessions? That
No, they're not public sessions, so they're only the parties to the appeals can attend them.
Yeah. And is there any record of the discussion that takes place?
No, so mediations are conducted on a without prejudice basis. So everything that's happens in the room stays in the room. And it's only the mediation agreement and the documents that are filed with the court at the end of the day that come out of the mediation room. And the reason for that is that it enables the parties to have open and free discussion about all sorts of possible settlements without prejudicing their position if they ultimately have to, take a different line in court.
Yep, thank you. Mayor Lash, you had a question?
Councillor Maitland.
On the TTPP committee's role as respondents to the appeals, number 20, for each topic, staff will prepare a position paper for the committee outlining the matters appealed and suggesting an approach and bottom line positions for the committee. This will be presented to and discussed in a confidential session of the committee, with final positions agreed by the committee prior to mediation. If the committee's position is outlined and then in the mediation evidence comes up that is contrary to how the committee feels about it, what's the position there? If we're not fully aware of what is going to be presented at the mediation, we may not be acting in the best interest of the appellant or in our own interest.
Yeah, I mean that is the trade-off, because either the entire committee has to attend every single mediation, or you create a process to delegate your authority to somebody to attend mediation on your behalf. And we'll probably talk about this in more detail in the next paper, but the process that we are setting up is to have these position papers and have a really fulsome discussion with the committee in advance of mediation, so that we can really understand from you what your best possible outcome is in terms of a mediated settlement on the appeal. And then we go away and attend these mediations and do our very best to deliver something that achieves that. And we don't have, assuming that you agree with the process that we've set out and we'll talk about in the next paper, our delegation to resolve meals will inevitably have limits, and we won't go beyond those. And so in the scenario where some new evidence comes up that we just haven't thought about and haven't discussed with you, then that will be something that we'll likely have to bring back to the committee. But generally speaking, I mean, I've done a lot of these mediations now, and generally speaking, through this position paper process and the discussion with the committee in advance of mediation, we get a really good understanding of what it is that you want to achieve. And hopefully we can deliver a mediated outcome on that basis.
Paul Medrick, you had a question?
Thank you. For the hearings of submissions on the sites and areas of significance to Māori, we we hosted that at Arahura Marae. Will the mediation for this also be at Arahura Marae?
The venues for the mediations are determined by the Environment Court, but if that's something that the committee would like us to suggest to the Environment Court and the court's requirements can be accommodated at the marae, then I see no problem. We can talk to Joe about that.
I think it would be appropriate that we do it there on the marae. This is all about Potini Ngaipo's position, and yeah, it would just be good to conclude the process as we started it.
I understand that. We can take that offline and talk to the court about it, but ultimately it's their decision, so we'll see what they say.
Thank you.
Go.
Me?
Oh, if you can, you'll jump in. Alan's got a question.
Oh, is there Rex?
Regional Council.
Oh, Alice, I was seeing that all the mediation is likely to be on the West Coast. Can we guarantee that?
I can't guarantee that, no. I think it's very likely that they will all be on the West Coast. I know that the reason why we've put likely in there is because there are some appellants that are requesting that the mediations be held in Christchurch. But the position that we are taking is that it's appropriate for all of the mediations to be held on the West Coast.
Yeah, I'm happy with that. I really think it should be in a neutral venue on every subject.
Yeah, and that's what the Environment Court typically tries to achieve. You know, in previous mediations I've been involved in where there's no court to go and attend the mediations, they're held in venues like hotels and conference rooms and things like that so that they are neutral.
Okay, thank you.
The Regional Council office, did you have a question? Someone, Daryl or?
Yes, thank you, Mr. Chairman. Thanks, Alice. You mentioned quite early on that, quite rightly, that the costs of the Environment Court commissioners and all the logistical costs with meeting rooms and those sorts of things are met by the Environment Court. But could you just confirm for the joint committee that over and above that, all other costs by all other parties lie where they fall, and all other parties need to meet those costs, particularly in terms of appellants and twos and fours and any representation, etc., including the district councils. And of course, from a regional council perspective and the targeted rating, we fund the team that represents the plan with Alice and co, but all other costs lie where they fall. Could you just confirm that, please, Alice?
Yes, yeah, that's correct. The only exception to that would be if we went through the whole process and we had a hearing in the Environment Court on a particular topic and then somebody made an application for costs at a later date. But typically, the court is quite reluctant to award costs in plan making appeals. So yes, absolutely, everyone has to pay their own costs in this process.
Thank you.
Don't think there are any other questions from that on the process. So the next paper is the appeals position settling process and the delegated authority.
Does Mayor Lash have a question?
Yes, I struggle with the fact that some of the appellants that have to pay to appeal when it seems that some of the points in the plan, especially relating to boundaries, are sort of not consistent with what the appellant thinks. And I feel that in those sort of cases, if it's found that the boundaries are incorrect, that the appellant should be recompensed for any costs.
mean, ultimately, that's a decision for the Environment Court to make. So if I don't like to talk about winners and losers, but if somebody wins an appeal and they feel like they are entitled to costs from, or to have their costs paid by the other parties involved in the appeal, that might be considered not the winners, then it's on the person who won to make an application to the court to ask for the court to determine that its costs be paid.
Thank you.
Okay, if there are no further questions, we could just move on to the next paper, which is on page 13 of the papers. Thank you, Alice.
I'll start with this one, Mr. Chair. Thank you. That's fine. Alice and I will be teaming up on this paper. This one's really a process report. It's to help ensure that appeals run efficiently and that we want to support the resolution of appeals to work efficiently and effectively. So we're going to do all we can to set the process up to run really well and smoothly. So that's what all this paper is really about for you. I'll miss a whole lot of stuff that other people have already covered, but start at point 6. We've got all the appeals and 274 applications in now. So staff are working on breaking down all the points and grouping them into topics that Alice mentioned. They go into topics, and what that means is, for some people, like Councillor Maitland was just describing, there could be an individual who just wants to change the zone on their property. One appeal point is about a specific thing, but many, and particularly with all these larger businesses, companies that have appealed, they're appealing across, say, noise, the environment. It could be anything, any number of things. So they cover broad spectrums of the plan. And so what the staff are doing at the moment is breaking up these appeal points and saying, oh, so from a certain appellant, they've got these ones on mining, they've got these ones on the environment, that sort of thing. And so to achieve what Alice was talking about, which is to help the Environment Court figure out who needs to be at a mediation, how many people, how long they might run, we give them this information saying this is the number of people who've appealed or been a 274 party on this particular topic. So that's where we're at the moment, is analysing all the information that's come in and trying to get this information to the court to help them make decisions on the timetabling for mediation, how long they're going to need, when they might be timetabled. So this includes even talking to appellants and 274 parties about when they're available and how long they think they might need to prepare for any mediation, that sort of thing. And the other point is, before we go to mediation, there are still some people that we can go back to and explain to them that perhaps they've misinterpreted the plan as it was intended, or that the committee has already approved changes under the Section 16 minor amendments, and those changes that they might have appealed we've already made those changes, things like that. So first of all, we'll have emails going out to these people and maybe some Zoom meetings if we need to see if we can sort those out, and then the rest of them will be sent on to the Environment Court to timetable. So from your perspective, you are the respondent to the appeals as the TTPP committee. That means that that's because all your decisions, the plan that you've made on the plan, are the ones that have been appealed. So you're defending, in the first instance, you're defending everything that you've decided, because appeals will want something different. Sometimes they're in support, sometimes they're in opposition, but often they're asking for some little or large change. So throughout the mediation, I know that we all generally understand what mediation is. Different parties are trying to achieve an agreed position. So it does mean that just because you're the respondent doesn't mean that you have to stick with everything that you've agreed on. You can make a change during the appeals processes. In fact, that's going to be required, that there's going to be some compromise from all parties to reach agreement on the appeals that have been made. So it's not set in stone, and that's why setting a position is really, really important, to say, look, these are things that we really don't want to change because they're so important to us, and these are things that if the wording changes and it doesn't have huge negative impacts on the implementation of the plan, we're actually quite comfortable with those sorts of things. So that's the stuff that we will discuss on each topic with you. Remembering that you're not the decision maker and the court is, so any agreement reached between the parties as a result of direct discussion or mediation is going to be submitted to the Environment Court for approval by way of a consent order. Anything that we can't reach agreement on through direct discussion and mediation will end up going through an Environment Court hearing. And obviously staff and legal counsel would be required there. So generally we would prefer to try and resolve as much as we can through appeal, and that's what the appellants want as well. They don't want to have the time and costs of going to court where it isn't necessary. At point 15, I'd just like to quickly talk about the principles for your position setting. These are things that staff recommend to you. The starting point is that you are defending decisions on TTPP. So that's the perspective that you are looking at every appeal from. Any position has to be consistent with the law, so the RMA and this hierarchy of planning that you've heard about that district plans have to comply with. So no recommendations can be contrary to the law, and a mediator or the court would not allow that to happen. So always keep that in mind when you're setting a position. Where possible, your position should be future-proofed. So we know that there's conversations about bills happening at the moment, but until they're enacted, they're still not law. But it's good for us to remember the discussion that's happening there so that, we can keep that in our minds when we're having discussions about your position that you want to set. But always remember, and this is something that is easy to forget actually, when there's lots of other things being talked about around the periphery, and you think, oh, that's a good idea, maybe we should bring that in, that you can only have discussions in mediation and the court on things that are within scope of existing appeals, so they have to have actually been brought up in appeal. It can't be something new. I think we believe that one of the most important things is the next point is to prioritise positions which will minimise the impacts on private property owners in terms of giving them any additional regulatory burden. That has always been something that's been a very strongly held belief by the committee. And when you're setting your position, I'm sure that you'll want to keep that front of mind. Always be pragmatic. Okay, if an appeal seems reasonable and it's actually not going to impact terribly negatively on implementation of the plan, then just support the appeal point. You don't have to disagree with everything just because you're defending your plan. So, keep an open mind on where things you can support an appeal easily and deal with some of the points quickly. Always keeping in mind that this is not going to be the end of the process. Planning is just an ongoing process, and we've already discussed opportunities for plan changes in the future. So whatever comes out as the operative plan, you already know is not going to be the final plan, because things do change with time. And then finally, on matters with specific technical requirements, generally take the approach which is defendable because you've had some technical expert advice on it, because we're not the experts on everything. I'm happy to discuss any of that, like process or the principles that you might have, if you've got any questions on those.
Thank you. it's a good place to pause. Any questions or comments on those comments?
Yeah, just a question there, like we were just discussing this morning, this is the first time we've sort of seen the language about being future-proofed and looking at future bills. Some of them have been introduced, some of them haven't, but the language right through this whole plan was saying really that we weren't allowed to take that into consideration. So we're quite interested in that point.
I think, Lois, are you happy to?
Yes, through you, Mr. Chair. I guess that this is actually a principle which I think the commissioners did take on board in hearings, but we are always hamstrung by the law is the law is the law. I've told you this many times, but I guess we know we're in a period of quite significant reform, and the government is, for example, this year we've seen a number of new, a couple of new national policy statements and changes to national policy statements and national environmental standards, and they have been gazetted, so we have to take those on board. But we're also having new things released as bills and as drafts. And so we do, I guess it's that thing about within the constraints of we must act within the law, we do want, we'll recommend that we try and have a pragmatic eye on that. And if we can see a clear direction and it fits well with the existing legal framework, then we should not have our heads in the sand about the changes that might be coming. But we are still sort of in that straitjacket of what has been passed into law. But we know that almost definitely during the mediation process, there will be things that are passed into law or gazetted, which will have an impact on potentially the committee's position or have an impact on the position of some of the appellants. This does mean we probably need to be a little bit, we might need to come back to you sometimes, and we will probably set the positions or bring the position papers to you to try and settle the matters that don't look like much is going to change early, and try and leave the things where there is a lot of kind of signalled change towards the end of the mediation process.
Thank you.
Regional Council Office.
Thank you, Mr. Chairman. Yeah, I've got some advice to offer here to the committee. Firstly, the coalition government has a stated objective to be passing into law the two new RMA replacement acts before the election by about mid-year. It is, however, noted that there is going to be intense negotiations and discussions at Select Committee, even amongst the three coalition partners, around the current form of those two bills. The moment they do pass into law, and this is why we've got to keep that watching brief and keep a weather eye on that, they do pass into law, that will affect potentially any provisions in the TTPP, and they'll be worked through and brought back to this joint committee and as well through to the court. In that intervening time, there is the prospect of a significant amount of national direction underneath the replacement acts, which is MPSs, regulations, etc., that could be gazetted and passed into law. And again, another weather eye on that and making sure that we're aware of where that's sitting and what that might mean. But all of that must come back to the joint committee so that you're well aware of what that is and what it means in terms of changes in terms of the final decision making. Hope that assists. Thank you.
Thank you. Any other general comments? I had one.
Just a couple. Just one from me. Sorry.
Sorry, Francois.
Yeah, just within the recommendation 2B and 2C, can someone explain to me the difference between them? It sounds like it contradicts each other.
Thanks, Sam. Can we just wait and pick that up in the next section of the papers, Paul? Francois? I think Joe will cover that in the next section of the paper.
Yes, we will.
Okay.
If I could just pick up on a minor, which Joe / Alice might be able to comment on this, the second bullet point in that the position taken must be consistent with the RMA and must be in accordance with the law or something like that. What would be an example of a position which would not pass that test? Can you comment simply?
Alice?
Yeah, I guess a really obvious example would be if you decided to take a position, for example, that you didn't have any natural hazard protections in your plan, or you didn't identify any outstanding natural landscapes. Those sort of big ticket items are examples.
Okay, thank you. Right, if there are no further questions, just ask Joe to carry on at paragraph 16 about the position setting process.
Yep, I'm going to hand over to Alice here. That's right, Mr. Chair.
Thank you, Joe. So I've touched briefly in the earlier paper on the setting of positions. So in order to enable us to have discussions at mediation, we need to bring the appeal points to the committee and understand from the committee what your position is in response to those appeal points. And as Joe has mentioned, the starting point is typically that the committee will defend its decision, but where appellants have raised good points, or they've identified new evidence, or there's something that you want to explore further, then there's an opportunity for the committee to think about that and to tell us that it wants to take a slightly different position in response to the appeal points raised, and then that gives us some scope to try and reach a mediated outcome in the mediation setting. So typically we will bring these papers, they'll identify the appeal points, and we will be focusing on the broader policy outcomes or sort of bottom line type things that give us a really good understanding of your thinking and how it is that you feel about the appeals. But we try to avoid specific hardline positions in the position papers because they make it really difficult to mediate. And when we turn up to these mediations, we have to confirm to everybody in the room that we have authority to settle on the day, and we'll talk about that a bit more later on in the paper. But the setting of positions is a really important part of that. And so we will be saying to the Environment Court Commissioner leading the mediation, yes, we've got authority to settle today, subject to some constraints. And that's just the reality of how councils participate in mediations. So you'll receive a report. It will identify the appeal points in a particular mediation topic, and it will make a recommendation to you from staff about what staff think the committee response to appeals should be. But ultimately, it's then open for discussion for you to tell us what position you want to take. The position being set in the committee meetings is the position of the committee as a whole, and it's not the position of individual councils. And we're going to talk a little bit about how we'll manage the conflict situation now that there are councils have appealed particular parts of the plan and have also joined other appeals. But importantly, this position paper represents the committee position. Just noted that the full committee is not required to determine the committee's position on each appeal point, and I'll talk about that a bit more later when we talk about the process that we're recommending. And just to note, so as a result of the district councils appealing parts of the plan, those committee members representing the councils that have appealed won't be able to participate in setting the committee's position on the particular parts of the plan that they have appealed. And the reason for that is that you can't be both an appellant and a respondent on the same appeal point. That is a conflict. And so we've created a process whereby we think we can manage that going forward. So And I guess, sorry, just on that, the way that those councils now will represent their interests is through their own appeal. So it's not like you've lost all opportunity to participate. You're just going to be participating through your own appeal rather than through setting the committee's position in response to the appeals. Yeah, so a practical issue that arose. I can take your question now, if that's helpful.
Thanks, Alice. I just want some clarification on this because I mean, on some of those appeals, everybody bar, as you know, the four regional council have appealed. So where we've got Bola Grey, Westland and Petini Ngātahu appealing, so will that purely be managed from the hearing process by the regional council members?
Yes, so
Sorry, Alice, just before you answer, would you mind repeating the gist of the question? We couldn't hear that so well, Mayor Lash. Alice, if we could just cover off the question and then your response. Thank you.
Yeah, I can do that. So the question was, there are some appeals, some topics where, if you look at Appendix 1 in the paper, all three councils and Potini Ngātahu have been identified as parties to the appeal. And so that only leaves the regional council on the committee as the one, I guess, representative that's not party to the appeal. And the question was, in that scenario, is it the regional council committee members that determine the position? And so the answer to that is yes. In that situation where all of the three councils and Potini Ngātahu have joined an appeal either as an appellant or a 274 party, the process that we're recommending will have a subcommittee made up of only the regional council representatives, but also the independent chair.
The independent chair.
Yeah. And that is simply because the parties to the appeal you can't wear two hats. You're either an appellant or a 274 party or the respondent.
You know, I understand that. It just it's quite restrictive. I mean, you know, Buller and Petini Ngātahu have got are appellants, and a lot of them, followed by Grey, and I think we only have 7. But it's when you look at that, you know, it's I wonder whether we can do the best bang for the buck as far as ears and rationale thinking on the decision making or on managing these hearings and understanding the intent of the appealants.
Yeah, I mean, I guess there is, with this understanding, there is an opportunity for the councils to go away and really think hard about whether they want their role in these appeals to be as an appellant or as the respondent as part of this committee. And they could withdraw parts of their appeal, which would mean that they can then participate through the committee position setting process. But yeah, it really is just this is the consequence of having appealed parts of the plan and joined appeals as 274 parties.
But what about, like, you know, are you talking, so we wouldn't be able to take part in that whole topic because there might be only one piece of that topic that we're submitting on. So I understand not being able to take part in that particular part, but I can't see why we can't participate in the rest of it.
Yeah,
on that subject.
There may be some limited situations where that is the case, but the difficulty that we're going to have is with managing the information. So when the position papers come to the subcommittee, as we're recommending, obviously that discloses to you a lot of information that you can't then unsee in terms of what the committee's position is in response to appeals. And that's information that you can't have as appellants on the same appeal points. So, yeah, yes, there might be some limited situations where we can bring parts of the position papers to a wider group of people, but we don't know enough about the breakdown yet, and it might be that it's just simply too difficult because of the wide-ranging nature of some of the appeals that have been lodged.
So how then does mana whakahorona rohi fit within this process that gives us the right to do that? So how does that work?
As distinct from your role as an appellant, do
Yeah.
you mean?
Yeah.
Probably have to give that a bit further thought. If that's right, I can come back to you on that.
Cool.
Alice, Ashcason here. I assume these points have probably been fleshed out and tested in other parts of the country, and there's probably some legal precedent somewhere around it.
Yes and no. So obviously the combined plan is reasonably unique, and so we don't have a lot of examples of other councils going through this, but we certainly have a lot of case law coming out of the Environment Court where councils have tried to appeal their own decision. So you might, for example, have an infrastructure arm of council appealing a regulatory arm of council's decision, and the court has not allowed that to happen. It certainly doesn't look kindly on one organisation being both an appellant and respondent. So that's the, I guess, the precedent that we rely on.
Okay, thank you for that.
Sorry, Alice, I guess also too, I mean, like we're part of the committee, we're not in mediation. So we don't take part in the mediation processes. So we're not privy to that stuff.
Yes, yeah. I guess though the purpose of the committee meetings where we will set the positions is to be able to have a really open conversation about all sorts of possibilities in terms of settlement. And that, my job is to represent the interests of the committee. And my advice to you is that that information should stay within the committee as respondent and not be given to parties participating as appellants or 274 parties to best represent your interests as the committee. And of course, I should just mention again that the individual councils and Potini Ngāi Tahu, you can advocate as much as you want with your individual organisations about the position that you want to see through your appeal. It's not that you've lost an opportunity, you're just taking a different route now as an appellant as opposed to the respondent.
Can I ask you a question, please? Oh, sorry.
I understand that, Alice, but you just said before to encourage as much discussion as possible, but this restricts that quite extremely. That's what worries me, is that regional council is going to be assessing all this, followed then by Westland, and the other councils and Potini Ngāi Tahu are going to be restricted on that conversation, which you just said yourself is going to be critical. Yeah, I have a problem with it.
Yeah, I mean, I'm saying critical in terms of those who are in the room setting the position. And I guess, yeah, again, it's the important thing for the councils who aren't involved in the committee setting position. Sorry, bearing in mind the committee is not the decision maker now. So it is only one party attending the mediation with a particular position. All of the other parties will attend the mediation with their own positions, the councils and the runanga included, and together the heads in the mediation will nut out a solution. So yes, it's an important process for the committee to set its position as respondent, and for those who are able to participate in that decision making to have a really good discussion about it, but it's not the end of the matter. It's still got to be represented in a mediation and discussed in line with it has no greater weight than any other party's view once we get into a mediation. so the district councils have just as much, yes, sway or mana, you might say, in the mediation room as the committee does.
Thank you.
Sorry, just before we
Sure.
take other questions, Alice, if I could go back to the point that Francois Tumahai was making, that you were going to take some time to think about. Could you just clarify what the specific question was? I didn't quite pick that up from Francois.
I think the question was, what is the role of iwi generally, as opposed to its role as specifically as an appellant in this process?
Okay, thank you.
Did I capture that correctly?
I wonder, Mr. Chairman, if I could just come in there, just for the benefit of the rest of the committee. Potini Ngāi Tahu have a quasi-statutory agreement under the RMA, which is called Manawhaka Hana Orohi, with the regional council on the governance and oversight of regional council matters, and particularly in terms of natural resources, which involves a partnership with our treaty partner on those matters. And the question we need to put our mind to is, how does that formal agreement, which is quasi-statutory, it has recognition under the current RMA in law, how does that play out in terms of involvement in as a respondent on these matters? I think that would be fair sort of a summary of your question there, Francois.
That's correct. That's correct, Gary. Yeah, where does it fit within the context of this and what it does to us? Yes. Yeah.
And Mr. Chairman and the committee, we will put our minds to that and offer some advice. Thank you.
Great, District Council. Someone had a comment? Yeah, Councillor Gibson.
I still think that we're open to public scrutiny, and I think we should be totally transparent and have independent people, well, people that know, but looking after the subcommittee for us. Otherwise, we're just going to get shot down. They've been quiet, didn't they?
I'm not sure if
I would think
Alice
Alice
is
is
the question.
And you are that independent person, aren't you?
Yeah, so I guess my role in this process is to facilitate the discussion amongst the committee, to understand from the committee or the representatives of the committee what the committee's position is, and then to best represent that in the mediation setting. So yes, I guess I don't have a stake in the outcomes on the particular matters in the plan. My job is simply to represent you all and get the best outcome for the committee.
Thank you. Alice, other questions? I'd like to make sure this matter is fully explored. Could I just make a comment? A subtlety is that the members of the committee are not representatives of the district council or the Runanga. They're appointed by, and I think that must be borne in mind at all times.
Yes, and through the chair, can I just say that from my experience in mediation as well, it's very, as Alice has said, it's very, very important that parties can feel that they can mediate and negotiate in an absolutely free environment, free of constraint, so they can be open and can speak about matters that will remain confidential and privileged in the mediation. And also it's just fundamental that you can't be an appellant and a respondent. And if you put yourself in a position where you try to be both, you open yourself up for judicial review or other litigation. So it is really a fundamental point that we have to proceed with in our minds.
Thank you, Chair. Paul Medrick had a comment.
Yeah, thank you. So, yeah, I think we all understand the need for a separation here. However, this we're getting down to the pointy end of things now with this plan, and this plan is supposed to be, for all its foibles, it's supposed to be, by the West Coast, for the West Coast. This is supposed to be our plan for future generations, albeit with those unpalatable bits that have been inserted in by the government, like SNAs and outstanding natural landscapes, etc. But it's supposed to be our plan, and I'm really struggling with this proposed delegation because it basically is a lot. I see it as a loss of West Coast autonomy. With all due respect to Joe and to you, Rex, you're not from the West Coast. And that's a lot of power to be putting in your hands, that you make the decisions on our behalf at the tail end, right at the end of all this process. It's put in your hands to make the call. Albeit you'll be guided by these position papers, etc., etc. At the end of the day, it comes down to you guys sitting there and making the call on our behalf, and I struggle with that. It's mana motahaki. Mana motahaki is us making our own destiny, and I just don't see that this works.
Here would say,
yeah, I agree with you. I agree. Sorry, Rex, I agree with Paul on this. It was never thought. It was never. This was never the case, from my understanding. So, a bit grumpy about it, to be honest, and won't be supporting it.
we just come back to the comment about the term delegation as distinct from the position setting. So I think it's appropriate now just to move on to the next section of the paper on page 15. So if I could ask Joe Stroke Alice to come on to that, and then we'll pick up on the discussion about the delegation at that stage. Unless there are other comments before we move on to that.
I'm happy to move on.
Did you have a comment? No, I think Joe and Alice, if we could move on, I think starting at Paris 16.
25, yeah. So the process that we are recommending to enable the committee to set its positions is for the committee to appoint a positions subcommittee, which will be a subcommittee made up of all of the members of the committee, but excluding in each individual sitting of the committee, excluding those members who are party to one of the appeals that is in a particular topic that will be coming to the appeals subcommittee. The positions subcommittee. So in some cases, I think, as Mayor Lash identified, the majority of members of the committee won't be able to sit on the appeals subcommittee. Sorry, I've got another council I work with, and it's called the appeals subcommittee, not the position subcommittee. So it's very confusing. So there'll be some cases where only the West Coast Regional Council and the independent chair, as we have recommended it, will be able to sit on the position subcommittee to make the position. We did consider an option whereby we would appoint all members of the committee to the position subcommittee and then deal with the conflicts by way of recusals. So recusing yourselves from each topic where you have an interest, so as a party. But that, I guess the key concern that we have with taking that approach is the protection of the confidential information that needs to be disclosed in order to facilitate good discussion around the position setting. So, and we also considered not having a subcommittee at all and just simply appointing a delegate to set the position, but we thought that it's more appropriate to discuss the committee's position with the committee before making a call on that. I think that's perhaps all I need to say about the proposed committee structure, and perhaps if I just touch on the delegation point first and then take questions on both the committee structure and the delegation, if that's okay through you, Mr. Chair.
Thanks. And if I could go back to Francois Termahai's comment of earlier in the meeting, looking at
yes.
recommendations A, B, and C. Francois, does that help you now? You understand what's proposed?
Yeah, sort of. I've switched off, to be honest, sorry.
So just to explain that point, in the resolutions, the option recommended is to appoint a position subcommittee and to appoint all members of the committee to the subcommittee. But each time the subcommittee meetings are called, those members who are also party to the appeals that are being discussed will be excluded from the committee. So that's why B and C are set out separately there.
And I think importantly, the quorum is
Yes.
2 members.
The quorum is just 2 members, whereas the quorum of the current committee, I think, is 1 member from each of the participating entities.
Yeah, that's correct.
1 of 4 of the 6 parties.
Right.
Through that process, would it not be better to have at least 1 member from each representative council available?
I think in an ideal world, if the district council hadn't appealed parts of the plan and joined other appeals, yes, it would have been preferable to have representatives from each entity in the the positions subcommittee. But because we have to manage this conflict between appellants and respondents, it's just not possible. But I see that Lois has given it some more thought, and we might be able to split up the topics a little bit further in order to reduce the conflicts and enable more participants in the committee meetings. So we've just got to do some more work around that.
Thank you. Paul Metrick.
Thanks. Alice, you said a couple of times about the need to keep some of this information that's going to be disclosed confidential. What exactly do you mean by that?
So I mean, in litigation, every party comes to the litigation with a position. So in every appeal, every party comes to the mediation or to the hearing with a particular position. And as my role is to represent the committee's best interest, and in order to do that, I need to understand very clearly what the committee's position is in relation to an appeal, and then to build a case around that position and take it along to the mediation or ultimately to an Environment Court hearing if we end up there. And if other people...
Do you mind if I interrupt there? Sometimes the committee position could be, we totally agree with what the councils and Potini Ngāi Tahu have bought. We would love all those changes to happen. Here's our opportunity to do it. So it's not as if it has to be in opposition to all the appeals at all, is it?
No. And so just on that point, Joe, I expect that we'll work very closely with the district councils in the mediation rooms. It's just that this position setting process, we need to have confidence that our case is not going to be undermined by having had all of our thinking disclosed to the other parties, because our job is to represent the committee.
So if I can, I mean, so are you suggesting that someone on our committee might have loose lips?
No, I'm not suggesting that at all.
I don't see where you're coming from on this. Obviously, there's needs for confidentiality, obviously, but we've all signed up to that from the day we stepped onto this committee.
Yeah, I guess
what's the problem?
The problem is that it as a matter of principle, the members involved in the committee can't be both an appellant and a respondent on the same matter.
We get that.
So it's unavoidable now that the councils and Potini Ngāi Tahu have made a decision, with advice around the consequences of that, to make appeals and join as 274 parties. And so this is just the consequence of that.
West Coast Regional Council Office.
Yeah, look, I just want to emphasise the point that I think Alice is making. If the district councils and are part of the our appellants in the process, therefore not part of the delegated committee. They are, however, in the mediation with the representatives of the committee in a prime position to be negotiating with the members of the committee. So they are actually in the box seat in the mediation. So I fail to see why there is such an issue with not being part of the delegated committee members.
Thanks for those contributions. Any further comments to make?
Just on that, so Colin, with Colin's experience, could he be the person on the delegation?
Do you mean on the delegation in terms of
on the representative? Yeah, for the committee. If we're in mediation, if we're appealing. Sorry to do that to you, Colin. If you
look, honestly, I'm happy to be, because I'm very much in the same seat as Paul, in that it's very, very important as West Coasters that we are the determinants of the outcome in terms of the outcomes in terms of the plan. So, listen, I'm in the same space as all of us are in terms of ensuring that the West Coast perspective is retained here.
So that's a yes, he can be, Alice.
Yes, he can be. If you're talking about the next section of the report that I haven't spoken to yet, where we're appointing the delegate to attend the mediation on behalf of the committee. Is that
that's what we're talking? Yes, that's what we're talking about.
Then yes is the answer to that.
Thank you.
Would it be helpful if I just whipped through that part of the report now so that we're all on the same page as to what we're talking about?
Just before you do, just confirm, make sure that I know that I've got 11 screens here, and I'm ignoring me and Russell all the time, but I just want to make sure that everybody's comfortable with where we're at with the discussion so far? I don't see any other hands raised, so yes, thanks, Alice. If you could move on to the next section.
Thank you. So the next section is about once the committee has set its position through the positions subcommittee, there will need to be somebody who attends all of the mediations to be in a position at the end of the day to sign the piece of paper that says, yes, we agree that the outcome reached in this mediation is consistent with the position set by the committee. And that person is not alone in that task. So they will have advice from me about whether we consider it's consistent with the position paper. They'll have advice from the planning and other technical staff about whether it's consistent with the position paper. And then obviously they will have been involved in the position setting as well. So the recommendation in this report was to make that delegation to the project manager and also to the independent chair. And obviously we've had the discussion just now about an alternative. And I guess just the key thing to note in relation to that is that that person or people, whoever the delegated authority sits with, will be required to attend all of the mediations in person and participate in them. So that's just something to be aware of. And then the other delegation point in this paper, probably worth covering it off now and then take questions on delegations generally, is that we also need a delegate to help us through the process with procedural matters. So things like setting timetables and liaising with parties about venues and timing of mediation and the number of people and that kind of thing. So we're asking for a delegation to the project manager to enable the project manager to give us the instructions that we need to continue to liaise with the court and keep the process moving. So those are the two delegations that we're seeking through this paper, and I'm happy to take questions about that.
Questions? West Coast Regional Council, your hand is up. Is that deliberate or left over?
Yes, no, deliberate, thanks. I want to just play this out in terms of how this might actually work. So if the committee is minded to not give the delegation to the independent chair and the project manager, but to any committee members that are not conflicted by being the respondent and the appellant at the same time, so it can only be the respondent. So that's the first thing. Maybe the delegation stays with the committee members that are not conflicted. The second issue then becomes is those committee members give to, and this is a possible scenario here, I'm trying to be helpful and find a way through. They give the instructions to the independent chair and the project manager around the guardrails around what can be settled on the day, because as Alice said, the first question on the day is, do you have authority to settle? And we would always say yes, with certain conditions around that. If the mediation is settled within those conditions, then perhaps the independent chair and the project manager can bring back out to the committee members that are not conflicted and say, yep, we're going to settle. Here's the things that's in line with what your instructions were, and they settle. Where it's not, it's got to come back out. So what we're doing here is actually giving the delegation to the non-conflicted committee members. The main issue that I'm trying to raise here is that mediation, let alone court, could go on for weeks upon weeks and probably will. I'm not sure that any non-conflicted committee members have got the time to be present every minute of the mediation and the court fixtures day in, day out. And I wonder, Alice, if what I've just outlined might be a way around or managing that time commitment.
It's certainly an option. I guess my one note of caution around that option is that mediations are best work best where the documents are signed before anybody leaves the room. And so it would mean that, and that can happen at any point throughout the day or, the week that a mediation is set. And so if we have to phone out from a mediation when an agreement is reached, we'd need to have absolute certainty that the people that we need to talk to are available to take our call and to be available for the discussion to authorise the signing, because if they're not, then the whole thing can unravel and that's really untidy. So that's my note of caution, and I guess why we recommended having a person in the room that has that delegated authority. And of course those people, or the people that we have recommended to have the delegated authority, are accountable to the committee as well. So they will have to report back to the committee on the outcome of the mediation. I'm not sure that we've talked about that in the paper, but that would be my expectation, that when things are resolved, they're reported back to the committee.
Right. Other comments then, Grey District Council?
Push for just comment.
Could we have 3 so that they didn't have to be there all, so they could swap in and out if it was too much of a time commitment for 2 people?
Sorry, do you mean 3 people available by
3
phone?
delegations.
Oh yes, we can have 3.
Take the pressure off.
Yeah.
Thank you.
Sorry, just maybe to clarify the answer there, you can delegate to any number of people that you want, provided that you're clear as to how the delegation can be exercised. So if you want to have 3 delegates, but you want to make clear that you only need one of those delegates to sign, then that just needs to be made clear in the delegation. Or equally, if you have 3 delegates and you want all 3 to sign, that just has to be made clear.
Thank you. Paul Medwick.
Thank you. I think that's a good suggestion from Daryl. That we favour the handing this delegation to Colin, for instance, and those members of the TTPP committee who are unencumbered on a particular topic. I think that's a good way to handle it. 3 people is good. I mean, I won't be supporting the recommendation, which was for the project manager and the chairman of TTPP to have that delegation. I just won't support it. So I think this is probably a good compromise. It'll keep everyone safe, I think. Just a comment from me. We've been down this road of mediation before, Francois and I, with the mediation over the wetlands for the regional councils plan in the past, and it's a ghastly process. Don't be fooled into thinking that this is going to be all sweet and here's a way to find a nice everyone's going to be nice and around the table, smile at each other. It's not. It's dominated by lawyers, and it's an absolutely ghastly process. But there you go. That's just my comment. Thank you.
Thank you, Paul. Just if I could turn back to the recommendations on page 13, and at number 3. Paul, if I could just follow through with your comment, would you be suggesting that number 3 be extended to delegate the authority to make decisions to include how would you then phrase the next part? Any other member of the committee who's not conflicted?
I think so. I think we need to be specific that the chair of the West Coast Regional Council has the delegation to and with the support of one or two, whoever many there are, members of the TTPP committee who are non-conflicted. I think it needs to be spelled out.
Lack of conflict, it would leave you with Councillor Casson and the independent chair as well. So those are the three.
That would only be on occasions, perhaps. Yeah.
You would give the delegation, it would be for every single decision. But only one of them would need to be there to represent the committee's position.
Wouldn't it be on a case-by-case basis?
Yes, I wonder if I could come in and assist here, Mr. Chairman.
Thank you.
I think the wording should be that the delegation is given to any joint committee member that is not conflicted. I think, and I note that as an independent chair, you are a committee member, Mr. Chair. So you'd be included in that. But implied in that motion is that that recognises that on a number of points in the plan, that the likely outcome of that motion means that it comes back to Councillor Casson, Chair Smith, and Independent Chair Williams. That's what's implied in that motion.
Thanks for that contribution. This is a very important matter, so I wonder if we might just adjourn for 2 or 3 minutes, because I'm going to ask Joe and Alice to write up in particular paragraph 3 of the recommendations. Is the meeting happy that we just adjourn? It might even be 5 minutes for those of us who need a coffee. Alice, you had a comment?
Could I just ask one point of clarification? So are you envisaging that, so in a situation where all committee members are able to participate in the position setting, so nobody is conflict, and I think there's only one example of that, which is notable trees, but there are other examples where quite a number can still participate, that at the end of the delegation will be held by all of them. So when we get to the end of a mediation and we want to sign the agreement, we have to contact every committee member that is not conflicted before we can sign the paper.
Again, if it assists, I take your point there, Alice, and I wonder whether that matter comes back to what is a quorum.
Yeah, we could think about that, or perhaps the committee could consider whether it would be comfortable with the delegation just being held by Chair Smith and Councillor Casson as an alternative to what we've recommended in the report, given that they will be the two that are not conflicted on anything.
Yes. If I could go on from that, I can just give you this scenario, committee members. Let's just say that a mediation is set down for the whole week next week, just as a scenario. Let's just say that out of the blue on Wednesday afternoon next week, a mediated resolution is arrived at by parties. That would mean that urgent calls need to come back out from the room. And you need to be absolutely available to actually then come together on a Zoom call or a Teams call and vote and down tools on everything else, because as Alice said, before they walk out of the room, the document is generally, is signed, under the Environment Court Commissioner's supervision. Now that's a tall order for councillors and other members who have got all sorts of other governance jobs and other things, because you could be in a council meeting and all sorts of things. And there's a lot happening at the moment with local government reform and CCO and all those sorts of matters. And I just urge some pragmatism here. Thanks.
I think, Darryl, on that point, you know, regional
think
council come under that as well. So I think that sort of pull on time, focus and dedication covers all of us, not just the councils, district councils.
Agreed.
Yeah. Paul Metric had a comment.
Just further to that, I mean, rather than, I can see Alice's point that it could be a problem where trying to contact every member of the TTPP, but in those instances, which won't be very often anyway, perhaps that could just be delegated to one from each of the parties, and that's therefore the three mayors basically in the two iwi chairs. And that wouldn't be too hard. Wouldn't be too hard to contact us all by phone.
Rex, if I can,
Yes,
if I can just say something that yeah, from my point of view, I'm quite relaxed with the recommendation, the way it reads. I understand where you all are coming from, but realistically, we need to, I think, be approaching this as straightforwardly and as simply as we can, and not turning it into, you know, something bigger than it needs to be. So I'll be supporting the recommendation as it reads.
West Coast Regional Council, one more brief comment.
Yeah, thank you, Mr. Chair. Just a clarification with Paul's suggestion, that would be the three mayors and the chair of the West Coast Regional Council, Paul, that you're suggesting.
Through the chair, yes, but of course you're already there. You'll be there in all of those mediations. Is what we recommend, what we're suggesting. So you'd already be there, but it'd be on the instances where it needs the nod from the rest of the TTPP. Then in those instances, rather than going through all, 11 members, that it could come through the mayors and chairs, basically.
Thanks, Paul.
Alice, does that meet the whole intent of delegated authority? In most cases, I would say with councils, it's like the planning manager who has delegated the authority. That's why we suggested men, because I'll be in all the mediations, not for any other reason at all. But, you know, having to have someone in the room who can actually sign is a big point of delegated authority. And if they can't come out to make those calls, I don't understand how it would work practically. Just asking.
Yeah, I mean, practically, this is going to be really difficult to manage in the mediations. I'm not saying it's impossible, but it will be very difficult. And the reason for that is that mediation is a really complex process, and it can occur over a number of days, you know, could occur over a number of weeks for the really significant topics. And a lot of discussion happens in the room to enable the parties to reach an agreed outcome. And that is why I guess it's so important that the parties confirm that they have the delegation to settle at mediation at the outset, and for the people who have to make that decision to be able to hear the entire discussion before they put pen to paper and say, yes, this is consistent with the position that was set by the committee. It will be a really difficult task, I think, for the committee members to take a phone call on a random Wednesday afternoon, and they'll have me on the other end of the line saying, you know, hello, councillor, we've spent 5 days in mediation. This is the gist of what's happened. Are you comfortable to agree that this is consistent with the the position that you set on behalf of all of your fellow committee members? You know, that's a really difficult question to ask someone that hasn't participated in the discussion. And so I'm not saying it can't happen, but I'm just, I guess, cautioning you about what that will be like, and it'll be quite tricky, having not had the benefit of the discussion in the mediation room. So that is why we're recommending that the delegation be given to the project manager and the independent chair, who are really familiar with the content of the plan, really familiar with the members of the committee. They'll be involved in setting the positions with the committee. They'll hear all of that discussion, and they will be tasked with not going outside the position or set by the subcommittee. And I think, you know, with any delegation, there is an element of trust there. And equally, as the recipient of a delegation, those people will have to exercise that delegation really carefully, and exercise their own judgment when they feel like matters are stepping outside of the position set by the committee, and to bring that back to the committee in those scenarios. So yes, this alternative solution is possible, but my advice to you is that it will be really difficult to manage, and difficult for you all, I think, to manage, but that's your decision to make.
Okay, thank you, Alice. I think we'll take it into account, but also noting the views expressed at the start of this discussion by Paul Metrick concerning the West Coast element. Could I suggest, and I actually suggest, I'm going to adjourn the meeting for 10 minutes while Joe and Alice see if they can come up with some suggested words to extend para 3, and the rest of us can get a quick cup of coffee. We'll resume the meeting at 11 a.m. Thank you. I can put you on the spot and ask, how'd you get on?
I'm just waiting. Oh, Alice is just joining us now, and she's looked into the legal requirements here. So I'll hand over to Alice if that's all right.
Thanks, Joe. Can everybody hear me? I think I'm on. Right. Thank you for that pause. It was quite helpful because I had an opportunity to go back and have a look at the Environment Court Practice Note. And the Environment Court Practice Note is a document where it's basically a set of rules for how the Environment Court conducts its processes. So hearings, evidence, mediations, all of the various parts of the litigation process. And in that document, it makes very clear that where we are participating in mediation, the person representing a party must do so on the basis that they have full authority from the party to settle. And if there's any limitation of authority, then we have to advise the Environment Court 10 working days prior to the mediation happening. So I just wanted to reiterate that point, because we have to be able to confirm that the parties in attendance at the mediation have the authority to settle. We can't be in a situation where the authority to settle sits with somebody outside of the mediation room. The other important point to note from the practice note is, and I'm just scrolling down to make sure I get the right clause, is that anything that is discussed in a mediation process is confidential to the parties who are participating in the mediation process. So it's not possible for anyone who's in the room to communicate with people outside of the room about what's happening in the room. And in order to be able to talk about what's happening in the mediation room outside of the mediation room, we'd have to get the consent of all of the parties to the mediation before we were able to do that. So that's not practical in terms of being able to set this delegation now. So I guess rather than taking that time to revise the recommendation in the report, I've refreshed myself as to what that practice note says about the rules that the Environment Court applies to mediation. So the person with delegated authority has to be in the room, and what is discussed in mediation can't be discussed outside of mediation. So those are, I guess, some practical limitations to the alternative that we've been discussing. Perhaps one possible solution might be if the chair of the regional council was willing, would be to have a third delegate, which would be the chair of the regional council, but the chair would have to be available to attend the mediations that he was responsible for.
Just if I could clarify, if the delegation would only be to one person, so it's either the independent chair or the chair, or so that the project manager, so that when the timetabling is done, one could imagine someone saying, yes, I can be available for 3 days that week, and the Environment Court will say, yes, that's the expected time for that mediation, or worse to that effect. Clearly, we don't need all three.
No, that's correct. Yeah, we just need one of those three in attendance.
So, Joe, bearing that in mind, Paul Metrick, you had a comment before.
A practical issue that again, if there is an intent to keep the TTPP committee chairman with that delegation and the project manager, neither of whom live here, so that's more expense, isn't it? Because they would have to come in for goodness knows how long these mediations go. And that's accommodation and travel and all the rest of it. It's just another practical consideration because we're already faced with the expenses have gone through the roof for this.
I will be attending.
Another reason too that I support Colin and I still support having open that for another unencumbered member of the TTPP.
I'll be attending in my capacity as project manager to help run the process anyway. And that was actually the only reason that my name was put forward, that I will be in attendance at all of them.
Thank you.
So here's just quickly, Francois here, sorry. Hey, so clearly, with the statement you made at the start, Alice, that makes it pretty clear that the person, whoever is in that room is critical. So, knowing that now, is this process that you put in front of us to get that delegated authority person or whoever it is there another way, or is this the only option we've got in this paper? Has there been is there an other option to put people in this room? What is this the only is this it? End of story.
The only other option is that all non-conflicted members of the committee attend the mediation, but we haven't recommended that because it's impractical.
And that's it. These are the two options. There's nothing else.
Can I just come in here, Mr. Chairman, and say what I heard from Alice, but I'm testing this with you, Alice.
Mm-hmm.
And I'll play this scenario out. Let's just say that we go back to the independent chair and the project manager sitting in day out at the mediations with very clear guardrails about what they can settle on. In terms of indicating those guardrails and what their discretion is, within the bounds, what I did here is that you can advise the court 10 days before the fixture, the mediation fixture, around that you've got authority to settle, but inside these delegated bounds. And if you advise the court of that, then that gives you authority to come back out to the joint committee members that are not conflicted if you have to settle outside those bounds. Now, that does put us back into a high degree of trust with the independent chair and the project manager to stay within their instructions. But I would certainly have confidence in that. Alice, is that a can we contemplate that scenario?
Yes, that's correct. So if we got into a mediation and the as we've recommended, the independent chair or the project manager felt like they were getting to the limit of the guardrails, as you put them, then we would have to say to the mediation room, look, we've had some really good discussion today, but we don't have authority to go as far as you're asking us to go. And we need to take some time to go and talk to our committee and get some new instructions. And how that would play out is that we would then come to the committee and we wouldn't be discussing how the mediation played out and everything that was said by every party. We'd simply be coming to you with an updated position and saying, do you feel comfortable with this position? And if you said yes, then we would be able to go back into the mediation and do the deal, for want of a better term. But yes, absolutely, we've got that process available to us.
Thank you, Alice. And can I just confirm to the committee, I've done that multiple times through mediations, let alone court. Thanks. Yeah, thanks.
Mm-hmm.
And likewise, in the mediations that I've been involved with, being given a certain set position, and the mediation has gone past that position, then had to go back to the principal of the business to get confirmation they will go outside that guardrail. The other thing I need to make clear too, look, with what we're all dealing with at the moment in local government, I wouldn't have the time to be sitting in mediations personally day in, day out for a week or more or whatever. But certainly in a position to be able to assist when required.
Thank you for those contributions. I'd like to keep this matter moving. Joe, do you have any other comments, or would the best way for us to come to some conclusion would be for perhaps me to move the recommendations as they exist on paras 1 to 5? But Joe, do you have a comment?
Only I wonder if we can, we can change the, something in the delegated recommendation at point 3 to say making those decisions within the bounds set in the committee position paper or something like that, that would provide a bit more comfort to members.
Yeah, let's assume that that can be written in somehow. Any comments on that?
Councillor Maitland here. I think that the key thing behind all this is that the main thing is that it must be seen by voters or members of the public that they've been well represented by the members of the council. And for me, I think a lot of options that have been talked about now do not sort of adhere to that. You know, I think we've all signed up to this plan, and although it may be an issue being able to attend these hearings, that's what we're here for. And in that regard, I actually like option 3, or either that as suggested by others, that we maybe adjourn this situation and come back with a bit more information or ideas around approaching it differently.
Yeah, I'm happy to support that.
Thank you.
a quick comment from somebody? I'm not sure. Regional Council Office.
Yes, through the chair. Could I suggest that recommendation number 3, that the words just be added to the end of that recommendation within the boundaries set by the committee?
I was just going to ask for any other comments around that support from Mayor Russell. Greymouth District Council.
We support to leave this item on the table as well for more options and information.
Sorry, I didn't pick that up. Would you mind repeating that?
We support leaving this on the table for more information and options and to have more discussion on our team with it.
Oh, okay. Could I ask perhaps Joe or Alice a decision on this matter? What's the timing on that?
Like anything, as soon as possible. We've got matters that Lois is working through at the moment where we could be starting to resolve simple things. And we'd like to be able to bring those papers, the position papers that have already been drafted, to a position subcommittee, as soon as possible, to start getting some runs on the board, I guess, as far as resolving these things before anybody incurs too much time and cost. So I guess the longer we leave it, the longer it's going to take to resolve everything, and we can't progress with simple matters without this delegation.
Thank you.
If I can, through the chair,
back to Mayor Gibson. Would 1 week, a special meeting of this committee in 1 week, would that advance the matter?
Yeah.
Support for that from Francois, I take it. Joe, Alice, any comments?
I just wonder if we could, if that is going to be the course of action, whether we could separate out the delegation on the procedural matters, which is the delegation in point 4, because we need that in order to be able to continue to engage with the Environment Court and file our case management memorandum.
Thank you. So I would propose, to keep this matter moving, that the recommendations on page 13, receive this report, etc., approve, delete at this stage, para 3, delegating the authority, include what is currently para 4, and include what is currently para 5. Is that what we're talking about? With the firm intention that a special brief meeting of this committee be held to confirm the delegating authority within 1 week. Is that going to work?
I'm sorry, you might have to repeat that for me, Rex. I didn't quite follow. So are there certain resolutions that we're going to put to the committee today and certain ones that we'll leave lying on the table for a later meeting?
Yes, that's what I'm proposing for this discussion, that we approve 1, 2, 4 and 5.
Yeah,
and that within 1 week we come back and
do number 3.
The essence of para 3.
Thank you. I mean, that would work from a practical point of view.
Paul Metric, briefly.
That would mean approving the terms of reference, which embeds the proposal for the delegation be given to the project manager and the independent peer.
Ken, through the chair, I think all we can do today is actually receive this report, because we can't approve point 2 until we actually go away and seek the other options or information that we are asking for time on. To me, we can't do any more than just receive the report. That's my perspective on this. I'm not sure.
Could you perhaps do the 4 and 5, which is delegate authority to me just to carry out the practical things that need to happen? We can continue liaising with the court in the meantime. And just noting that appeals have been lodged with the Environment Court and they have the final decision. I don't think that those are probably under consideration either, and just pull 2 and 3 out for discussion in a week.
I'm happy with that, Joe.
Mayor Russell to speak.
Thank you.
Okay, I'll go back to what I said earlier on and put it to Alice. You know, taking a week to come up with other options, Alice, realistically, what I'm hearing, there are no other options unless somebody, e.g. Colin, who hasn't got the time, is prepared to actually take the place of the independent chair. Is that a reasonable summary?
Yes, correct.
Okay, so I'll go back to what I said earlier. I'll support the recommendation as it's written so we can get on with it.
Thank you. I'd like to keep the matter moving and, oh, sorry, the Regional Council Office had a comment?
Yes, look, I would just like to also keep this matter moving, because any delay is going to involve frustration of the team that are dealing with this, and also it's going to add to cost. And I think, you know, we are very close. The whole conversation we've had this morning, we were very close to getting it resolved on the basis that 3 is amended so that the delegated authority occur within the boundaries set by the committee. So there would be a boundary set for the delegated team. If they reach that boundary, they have to come back to the committee. And does that not satisfy the issues that we've been discussing this morning?
Okay, thank you for the comment. To keep things moving, I'm going to accept a motion from Mayor Russell, possibly seconded by Chair Smith, that the recommendations with the amendment of para 3 within the boundaries set by the committee. That's a motion that's up for debate. Do we have any comments on that? Thanks, Alice.
So I just make one point of clarification. It would be the position set by the positions subcommittee.
Correct.
Within the boundaries set by the position subcommittee. Yeah. Paul Metherick?
Yeah, through the chair, I won't be supporting that. I still think that we need that space to go away and to think about this rather than being railroaded at this moment. So no, I won't support it.
And I support Paul's comment there too. I mean, a week to we settle back on option 3 with amendments, so be it, but I would like some time, because this decision is serious. It is our last opportunity to pave the way forward for how we move through this next phase. And I'm not prepared to move in support of it.
Any other comments? There are none, so
We're against. We're against as well, as per our comments before.
I should have lost.
Sorry, I couldn't pick up that last comment. So the motion is, as I've explained, those in favour, aye, or raise your hand, because it's going to be very difficult to judge
Aye.
So we've got right, aye. Those against, raise your hand. So the motion is lost. So to keep the matter moving forward, the next motion I would propose from the chair is that the committee receive the report and that the matter is brought back to a special meeting within 1 week.
Rex, I'd like to test something else in the middle ground in the meantime. Joe's just put forward to us. Obviously, there's things that need to happen in this week. We need to keep things with Alice and Joe moving forward. Is there a middle ground between what you're saying, the full report comes back in a week's time, and obviously the motion that's just failed, whereby Joe and Alice are empowered to go forth and do what they need to do with the clauses of this motion, and then the rest of it comes back to us in a week's time for the final vote upon the bit that's actually contentious. I don't think the administrative stuff's contentious.
Thank you. So your motion is that the report be received and that para 4 be approved.
5.
Yeah.
And 5.
We'll second that.
Yep.
But
Support that.
moved by, I'm not sure, I'm just not.
Ashley moved that.
Seconded by Mayor Gibson.
1, 4 and 5.
1, 4 and 5. Okay. So the motion is that paras 1, 4 and 5 be approved. All in favour of that? Aye.
Aye.
Against?
Against.
Against. Mayor Russell against. Francois, I'm not sure, were you slow or against?
No, 4.
You're for, thank you. That motion is carried.
Thank you.
So, and as a result of that, Joe, I ask you to find the time for a 1 hour special meeting by Zoom within the next week to consider the rest of the recommendations.
Certainly.
Thank you. I'd like to keep moving. We're noting as we go through the Appendix 1 and the Appendix 2 of that paper.
Yeah.
Thanks, Alice. You can continue participation in the meeting if you like, but equally can understand if you sign off. I'll move to the next item on the agenda, the draft budget expenses. Joe, speak.
Thank you, Mr. Chair. So this report's all about the draft budget just for the anticipated expenses for 1st of July 2026 to 30th June 27. So you can discuss and approve those to present to the West Coast Regional Council for funding as was set up in the Order in Council. Excuse me. I've identified uncertainties that are inherent in all budgeting and specifically in this circumstance of moving into appeals and the assumptions that I've used in order to calculate some the expenses for you. Every year the committee has to set a budget to achieve its goals of preparing and notifying the plan, the things that we've gone through, but also implementing it and the ongoing maintenance of it and review through plan changes and things. So that's something that's always happened in the past. And committees in the past have developed and approved a budget for those functions. They cover things like the anticipated staff and resourcing requirements, but a reminder that it leaves the West Coast Regional Council to calculate the overhead expense that they charge to the TTPP for a number of services they provide, the level of the annual income that's going to be raised by a rate, and therefore what's not covered by rate, the amount of loan that's going to be required for the year. This is why I won't be presenting a full budget to you. It's just on the expenses that are specific to the TTPP functions outside of those things. Just a little bit of background. In the first 4 budgets, they were for the development of the plan and the costs were really well known. It was a certain amount of staff time and certain amount of resourcing, and we budgeted for a piece of research each year that we felt we needed to, that sort of thing. So those ones were largely accurate, within dollars most of the time. The 2024 budget included the first 7 months of hearings. It had been intended that hearings would continue throughout the whole 12-month period in the 2024 budget, but they started a little bit later than anticipated in the October instead of in the July. So that ended up that we had a surplus in that year because we budgeted for additional hearings. But that's also left us with both the 2025 budget and our current 26 budget meeting higher levels of uncertainty around the costs of the hearings that just seem to continue on, including expert input and time necessary for the hearing panel to produce its recommendations report, which was later than anticipated. So there was a significant budget deficit in 2025, and the increased hearing costs also have given us a deficit at this stage in 2026. So some of the budget assumptions and rationale. It's going to be another level of year of high level of uncertainty about what the expenses are going to be, because we just don't have control over the time or even the timing of mediation and court proceedings and the costs that they involve. The Environment Court controls that. So we are suggesting topics, grouping and timing that's going to work best for appellants, but we just don't know what that's going to look like until we get through all that operational process up front. A number of TTPP expenses still easy to predict: website maintenance, the hosting of the plan, some of those things. But if it's anything to do with the mediation and court processes, they'll be determined by the number and length of the proceedings and how much staff, expert witness, consultant planner, legal representation is required. And as Paul commented, travel expenses are commensurate to how many days mediation will continue for. But we will keep you informed about that in each of our budgets that we bring to your regular meetings. Let you know early if we anticipate any exceedances in the budget. So here are some assumptions that we've made when we've been setting this budget. There will be some early meetings with appellants, which will resolve some appeal points. So we're just going to send emails and maybe see these people on Zoom. So costs will be minimal for that. Please note, I've said here approximately 3 weeks required for mediation. I would think it will be 3 or 4 weeks, but that further down in this paper, I have incorrectly put 1 week, which was totally unintentional. I'll point that out when we get to it. So 3 to 4 weeks of mediation, and at least 1 week of mediation will occur in the 2027 financial year that we're looking at setting the budget for now. At least 2 topics will proceed to court hearings because the positions of parties involved in these appeals are diametrically opposed. They're never going to agree, and in fact we may find that in some cases a fairly early decision in mediation will be to go to court instead of continuing time in mediation. Legal counsel are going to have a high level of input. That's just the nature of this process that we're in. And it's also the same with expert witnesses. Ones that have been required at hearings may also need to be recalled to come and be expert witnesses in mediation if similar points are brought up in appeals that need to be represented from the committee's perspective. We will need some additional consultant planning help to represent you on a couple of the proceedings that the principal planner hasn't been involved in developing or involved in representing at hearings either. So they always come at an additional cost to our regular principal planner. Further research might be required. We might be asked to do some, or we might see that someone else has brought an expert witness and we need to understand that a little bit more, so that could happen. And travel expenses, as we've already discussed. So because of the high level of uncertainty, we're presenting 3 options this year: best case, mid-range, and worst case for the 2027 expenses. And I'll just, I think the best thing is for you, obviously had an opportunity to look at this paper over the last week, and if you've got any questions on any of these standard items, so the expense items on the right, they're all the ones that we have in every month's financial statement, so they're all familiar, and I've put the description there. The assumptions is where I put 1 week of mediation instead of 3 to 4 weeks, so I apologise for that, and I would like to be able to either change that in this paper before it is finalised, or just note that in the minutes that that was the intention there. But if there are any questions on the cost related to any of these particular items, I'd be happy to just deal with those individually for you.
Thank you, Joe. Questions or comments from committee members?
Okay, well, we have given the option of the mid-range budget for you to discuss, confirm, approve, on the understanding that that then goes to the West Coast Regional Council, who will add in interest rates anticipated for the 2027 year and their overhead costs. So once you've confirmed the budget option that you choose, we'll provide the West Coast Regional Council with this information so they can add it into their annual plan and make sure that they are raising a rate in the 2027 year to cover some of the TTPP expenses.
Thank you, Joe. Comments? There don't seem to be any comments.
Sorry, Rex, I just think it's fitting for us all to note that with this budget, even with the mid-range, this project is going to hit its $10 million threshold for this year. So this project so far is going to be a $10 million project before we even have a fully operative plan. I think we need to stop and pause and reflect on that. Not that there's anything we can do about it, but it's a fairly large milestone financially.
Yes, so Mr. Chairman, if I could comment too, look, the nominal sort of budget that was adopted from the Joint Committee back into the Regional Council budgets at the early inception of this project was $5 million taken out over a 10-year loan period with the interest accrued over that time. And the 10-year loan period was based on the fact that under the current RMA, a plan has a 10-year life before it must be reviewed. So that's why it was loaned over that 10 years. And as Councillor Cashin has just said, this project is now heading, or will hit double that budget, and that's a targeted rate that the Regional Council is going to have to revisit and reset its budgets on, including interest payments. Thank you.
So as the newcomer here, Daryl, is there any sort of comparison between what we're spending and other areas of a similar size, similar population, or whatever?
Good question, Mayor Russell. We've explored this before. There is many benchmarks that we can point to. We've done this exercise. We could even send you this information if you like. And it's really regrettable to say, but for one district plan for the size of the West Coast, even though we haven't got that many ratepayers, but for the size of the land area and the issues that this covers, even at 10 million compared to other district councils, this is cheap. This compares favourably cost-wise to, if it does end up being 10 million, it could be more than that, but to the exercises of district plans done by even individual district councils. And myself, Joe, Lois, and other staff are well acquainted around the country with what these things cost. RMA plan processes are extremely costly. We look forward to a simplified RMA that hopefully streamlines that cost. but at the end of the day, that is what it is. And just remember here, what we're doing is we're doing one district plan across 3 district councils, where the cost comparisons that we've done previously is one district plan for one district council, and even that compares favourably. So they are very costly processes, unfortunately.
Okay.
Thank you.
Thanks very much for that, Carol. I think it's worth, certainly leading up to me coming into local government, all I saw was criticism about the amount of money that had been spent. So I think, your answer is very important when we're talking to the media, to put it in perspective for the public. You may have done that or tried to do that previously, not being involved in local government, but sitting on the outside. I'd have to say that I certainly didn't pick that up anywhere in the commentary that has taken place to date.
Between about half and a quarter of other people's expenses for these processes to date.
Okay, any other comments on the paper?
To the chair, to Councillor Maitland, it's sort of interesting to note that the first suggestion to save money by amalgamating the 3 councils was to save money, but I think it'll be quite some time before that saving will be realised, considering the cost of the program today. And I just sometimes wonder if on the outset that the Department of Internal Affairs would have been better to inform the people that first made the suggestion that these costs further down the track will be quite in excess of what they were hoping to save in the first place. And so in that regard, I feel that the DIA has sort of failed in their representation to save costs for the coast. And yeah, I'd like to see that sort of attitude change. Thank you.
Thanks for that. Paul Medford, a comment?
Just a comment in response to that, and the comment noted by Chris. We have not disagreeing about the horrible cost of this. We have tried to rein in those costs since it was first kicked off, and but what you have to keep in mind, as has been pointed out, and Chris himself said he hadn't realised this, but we had tried to hammer this point home with the public, that the individual councils, Buller, Grey and Westland, were up for this anyway, because with or without a TTPP, those individual councils had to redo their district plan, and that cost would have been on those councils alone. So there is no escaping this. This way we've wrapped it up into one. And as Daryl said, as one, at $10 million, it's no one is happy about that. However, divided 3 ways, because each of those councils would have had to have done it anyway, because all those plans were expired.
Correct. Yeah, thanks very much for that. I'm not criticising the total cost, and I understand, Robert, exactly what you're saying. My only comment was around messaging. When we're answering media comments and criticism coming in about the cost, you've made really, really good points. I'm just saying that before I came into local government, as a resident, as a ratepayer, that message wasn't getting to me, and I was following these things, really closely. So, I mean, it's just a messaging thing. I don't know how you do it, but you make some very good points, and we should be cognizant of those when we're putting out or responding to media inquiries.
Thank you, and for that comment. I'll come back to the messaging. I'd just like to come back to the recommendation on page 22, and noting Joe's full explanation of how these figures were arrived at, someone prepared to move the recommendations receiving the report and para 2 about the draft budget expense to go to the West Coast Regional Council. Someone brave enough to move that?
Moved.
Councillor Russell's, Mayor Russell has moved. In the absence of Paul Madrick, thank you, Paul, has seconded that. All in favour, say aye.
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 Carried. Against? No, that's carried. Thank you. As far as the messaging is concerned, an important thing, and we do have the opportunity to, after these meetings, to be in touch with news media, to provide a press release. And Joe, I think this is one particular occasion when we should draft something up, circulate it, and just make sure that the committee members are comfortable with the message that we're sending out, and go from there. So if you could put that on your list of things to do, Joe, thank you. Then to the financial report to the end of December 2025. Thank you, Joe. Brief.
Thank you. Yep, I'll be brief. For the first 6 months, due to excess in expenditure above the budget for hearing commissioner fees, the resulting unfavourable variance after 6 months is $195,000. Positive variances are helping balance that. And you can see all that information on table 1 where we're at the moment, and I'm happy just to take any comments on where the budget is currently. Otherwise, moving on to table 2, which is the life of the project to the 30th of June 2025 table, shows the expenditure totals for each financial year, and then in the right-hand column it shows the total project cost to date, which gets updated each month. And you'll see now that next to that a column has been added that's headed current year to date, and that shows the figures for the current financial year, which are just pulled straight out of table 1, and that was at the suggestion of Councillor Casson. Thank you. That should make it a little bit easier to understand how everything adds up there. And a reminder is we have already discussed that where the annual rate hasn't covered all the expenses, a loan's been taken out, and the amount required in loan is identified at the bottom of the table as the net surplus or deficit, always a deficit. And in the far right hand corner you will see by the end of December last year we were at almost the $5 million mark for requiring a loan for that amount.
Thank you, Joe. Comments, questions about the financial report? I don't see anybody with a question. Could somebody move that the report be received? Moved by Councillor Webb, seconded by Councillor Casson, I think. Thank you, Ashley. All in favour? Aye.
Aye.
Against?
Aye.
Carried. That concludes the meeting. So just to reaffirm that we will be looking for a 1-hour Zoom meeting to pick up further on that matter that was not finalised. Okay, with that, I'll close the meeting. Thanks for your attendance. And my apologies for the late running of the meeting. It's a first for this committee after 7 years. I think it's the first time we've run over time. So my apologies, it won't happen again.